Hello to all our viewers. I'm very excited to be joining you today. I am Lizali Rasmus. I am a civil legal practitioner working for Legal Aid South Africa's advice team. Today, I will be unpacking two critical human rights, Section 32 of the Constitution on access to information, as well as Section 33 of the Constitution on our right to just administrative action. This is our 7th Facebook Live broadcast focusing on human rights this month. March is Human Rights Month, and we are using this time to spread awareness of our human rights and answer any questions you may have about your rights. You can leave comments or questions below. I apologize. You can leave comments or questions about human rights below. If we cannot respond today during this video, look out for a message from us or a response in a future video. If you require legal assistance, you can call our toll-free advice line on 0800 110 110, weekdays between 7 a.m. and 7 p.m. If you cannot call, please send us a please call me to 079 835 7179 and we will call you back. Like and share this video to spread our word on human rights. So if we can start, then first of all, I would like to discuss Section 32 of the Constitution. And I also brought the Constitution so that everybody can have a look at what it looks like. Section 32 of the Constitution states that everybody has a right to access information from the state or from any other person, but this information is needed to exercise a right or to protect your right. I apologize for that. To give effect to this right, the legislature created the Promotion of Access to Information Act. I would today like to explain and maybe a bit simplify this act for our viewers. First of all, we need to understand from whom can information or records be requested. Here we have two options. You can either request it from a public body or from a private body. Now, first of all, we need to understand what a public body is. And this will include government departments, all government departments, but it does exclude the cabinet, members of parliament, the provisional legislature, as well as judges of court. On the other hand, we have private bodies, and this means that it is a body that is privately owned. And you can only request information from a private body if you need this information to exercise a right or to protect one of your rights. Now, this act put in place certain structures that needs to be followed. For example, government institutions needs to provide us as citizens with a manual. This manual is for you to know what that governing body is about, and it's very important is that they need to identify an information officer. So that is one important term to keep in mind when we work with this act. The information officer is the person that you are going to request your information from. Now, who can request information? If you have something that you would like to request, an information or a record, you are probably asking yourself, can I request those information? Do I need an attorney to do that? Or who can help me with this? The answer is very simple. Anyone can request information. You can even request information on behalf of someone else. Our next question is what records? What information can I request? Now, records are recorded in different manners. For example, it can be a hard copy, it can be on a computer file, or a video, or a tape. So different types of information can be requested, or you can request this information on behalf of someone else. If you work through the act, then you will be referred to as the requester. It's funny, the requester. Right. Now, a very important part of this act is how. How do I request information? Now, the Government Gazette published a prescribed form on which you need to complete the information that you request. Now, what you need to do is you please need to put in as much information in this request form as you can. First of all, obviously, the most important is your information: name, surname, postal or physical address. Sufficient information about the record or information that you require so that the information officer can find that information for yourself. As we said, this must be done in writing because it is on a prescribed form. You must also state what language you would prefer correspondence in and in which form would you like to receive this record or information. Meaning that if you would like a tape or a record, for example, would you like to view that tape or the record, or would you just like a copy? If it is a document that you would you like to see the original, or would you just like copies? That is information that they would need from you that needs to be filled into this form. And then your request, how must they respond to your request? For example, must it be via email, or do you prefer postal address, for example? Now, it's very important to note that there is an access fee payable as well as a request fee. So when you fill in your document, your request form, there is a request fee payable, and these fees are set out in the regulation of this Act. So I'm not going to go into details about exactly what amounts there is. You can check the regulations to this Act, please, to see what fees are payable. But please note that if you have not paid the request fee, your request won't be processed. Then after you've paid your fee and your request has been processed, then they will inform you whether they are going to assist with your request or not. If they are saying that yes, they will request, then they will need an access fee. Now you will say to yourself, oh, another fee. But this is for the time period, for example, it takes them to find the information that you need. As I said previously, maybe you would need copies, the cost of the copies that it's going to need to be made, or if a record will need to be reproduced. So that is the reason for the access fee. Now, you have filled in your form, you've paid your prescribed fees. Now, how long do you have to wait to get your information? And the answer is 30 days. If it is maybe information that is quite old, that can be in archives, or it is, let's say, for example, a record that needs to be reproduced, and the information officer needs to look for this information, then they can request you if you would agree to a postponement of another 30 days. But in general, in public departments, the investigating officer has 30 days, and in a public and in private bodies, the head of that private body has 30 days to respond to your request. If within 30 days they either deny your request or they haven't come back to you, then you can appeal this decision that was made. And please note that your appeal must be submitted within 60 days from the date that you receive the information that your request was denied. There's also an appeal fee payable, and this fee you will also get on the in the regulations of the Act, as I stated previously. So please, the appeal fee needs to be paid, and then there is also a prescribed form that needs to be filled in for you to appeal. And please remember that if it is a public department, your appeal must be lodged within 60 days. Now there's again a difference. So as we said, if it is a public body, you can request any information. If it is a private body, the information that needs to be requested, you would need that for your rights, to protect your rights, Right. Now, if you request the information from a public body, you use the information officer. You send the documents to the information officer. If it is a private body, you send the information to the head of that department or that private body. Furthermore, that if it is a government institution, most government institution has got an internal appeal process. So you will first need to use the internal appeal process. For example, the Department of Home Affairs has an appeal board. So you will first need to appeal to the appeal board before you can bring an application to court. On the other hand, a private body, you will need to go directly to court as they do not have an internal appeal process, and the Act makes provision for that you can go directly to court. So now your appeal has been finalized and you are still not happy with the outcome, or they are still refusing you access to certain documents. What can you do now? Then you can bring an application to court for assistance and to help you to get these documents. What you please just need to keep in mind is that in terms of this Act, there are several grounds on which they can refuse you access to this information. I'm just going to name a few, but there is quite many of them that is stipulated in the Act. And this is, for example, the protection of the privacy of a third party, the protection of certain records of SARS, the protection of commercial information. And what is this? This is like, for example, trade secrets, the protection of a police docket in a bail application, privileged documents in civil legal proceedings, as well as confidential information, or if the information that you are requesting threatens the safety of people, then the department can refuse to provide you with this information. But the Act is very clear about one thing, that disclosure is mandatory if it is in the public interest. Then the Act also makes provision that the Human Rights Commission must implement this Act, as well as help people exercise their rights in terms of this Act. So I hope this helped to get a better understanding of this Act and how you can request information if you need information either from a public body or from a private body. And please, as I stated before, if you need further legal advice on this or you need some clarity, you're more than welcome to phone our advice line on 0800 110 110 for assistance. Secondly, I would like to discuss Section 33 of the Constitution. In terms of this section, the Constitution states that every person has the right for administrative action to be lawful, reasonable, and procedurally fair. And if you find that administrative action was not fair, then or it adversely affects your rights, then you can request reasons. And to give effect to this section in the Constitution, the legislature created the Promotion of Administrative Justice Act. In terms of this Act, let's do this. Let's rather start from the beginning. First of all, what is the administrator? The Act refers to the administrator and it refers to administrative action. Both. We need to understand them in order to understand the Act. So let's first clarify what is the administrator. So that is all government departments, and this includes the police and the army, as well as parastatals, for example, Eskom and Telkom. Now our question is, well, how does this apply to me? What is administrative action? Any decision taken by an administrator that adversely affects your rights is administrative action. Adversely meaning negative. If a decision that they take affects your rights negatively, then that would be a part of administrative action. Now let's look at a few examples. If you, for example, apply for a disability grant at the Department of Welfare and their decision whether to grant or refuse, that will be administrative action. If you, for example, apply for a birth certificate for your baby or an ID document at the Department of Home Affairs, their decision whether to deny or give you your application will be administrative action, as well as for asylum seeker status. That would also be part of administrative action. Now, how do we do this? How do we apply for an administrative action? How does this work? How is this applicable to ourselves? Now, as the court stated, as the Act states, that you need to have, the procedure needs to be fair. And what does this mean? So before they take a decision, they need to inform you what they are going to do. And you need to be able to tell your side of the story. And after a decision has been taken, they need to inform you what the decision was, that you have the right to appeal this decision, and you have the right to request reasons. Now you may ask yourself, how does this act apply to me? How is this act going to assist me? Now let's say, for example, you apply for a driver's license, or you already have a driver's license and then you need to renew, and both is refused. This is when this act comes in, and when this act will help you to protect your rights. Meaning that before they make a decision, they need to inform you what they are going to do. For example, the Department of Home Affairs, for example. If their decision is going to negatively affect you, they need to inform you about this, and you need to state your case. Meaning that maybe they left out some important information when deciding on your matter. You need to inform them in order for them to consider that as well. When your application was refused, then you have the right to request reasons so that you know why was this refused. And if needed, you can also appeal this decision. Now, let's first have a look at, let's say, for example, your driver's license was not renewed. And you stated your case, they considered, and they still refused. What do you do now? First of all, you need to request reasons. Reasons needs to be requested 90 days from the date on which you found out that your application was refused. Your request must be in writing. You need to set out your personal details, details of the request that was denied. So please make sure if there's a reference number or anything on previous documentation, please include it in your request for reasons in order for them to find your request and sort out your request quicker. And then as well as your preferred language. If you cannot write, please ask a friend, a family member, even a paralegal to assist you when writing your request. The administrator then has 90 days in which they can respond to your request for reasons. Now, please note, when they give you reasons, they don't need to give you an explanation on why they didn't grant your request, but they need to tell you on why or how did they get to that decision that they made. So you receive the request, you receive the reasons, apologies, and you are still not satisfied. What do you do now? Then you need to follow the internal appeal procedure. Most governing departments has internal appeal procedures. For example, the Department of Home Affairs has an appeal board. You first need to appeal internally, and if you're still not satisfied, then you can bring an application to court. But please note, if you're first going to court, the court is going to refer you back to the specific department in order for you to first appeal the decision before you can go to court. And so your appeal is refused, you are still not satisfied, then you may go to court. And you need to bring your court application within 6 months from which that refusal was noted by yourself. So I hope this helped you to have a better understanding on what is administrative action, who is the administrator, and what can you do to protect your rights. Please note the time periods. Time periods is very important, and sometimes we forget to keep to time periods. We are so upset that a reason didn't go as we planned that we do not keep to those time periods. So please, when applying for written reasons or when you appeal, please keep in mind the time periods as I discussed in order for your application to be brought in time and that there is no unnecessary delay in your matter. So thank you for joining us today. If you have any further questions, please do not hesitate to contact us. You can send a Facebook message, or if you require legal assistance, you can call our toll-free advice line on 0800 110 110, weekdays between 7 a.m. and 7 p.m. If you cannot call, you can send a please call me to 079 835 7179 and we will call you back. Join us again on Friday afternoon for our final Human Rights Month Facebook Live broadcast. We will be discussing our rights to housing. Check in on Facebook to find out when our conversation will be taking place. And send us your questions, and remember to like and share this video to spread the word on human rights. Thank you very much and goodbye.